a stunning turn after the defense wrapped up, Advocate Baloyi returned to the podium like a man on a mission. And then he dropped a bombshell. He reached all the way back to a 1939 court ruling, yes, nearly 85 years ago, to defend his right to grill Muzi Sibiya using Ntanzi's alleged statement. Baloyi declared that this ancient precedent gives him full legal authority to do exactly what the defense is trying to stop. According to him, the law is clear. A co-accused's statement can be used in cross-examination, not to prove the contents are true, but to test the witness, expose contradictions, and challenge credibility. He fired back at the defense's accusation that he's trying to sneak in a confession through the back door. Baloyi said that's nonsense. He's not proving truth, he's testing honesty. With confidence, Baloyi told the court that this principle has been recognized for decades, long before anyone in that courtroom was born. So, in his view, there's nothing unlawful, nothing improper about his approach. He then urged Judge Ratha to reject the defense objections and allow him to continue his cross-examination. Will the judge side with him? Or will the defense push back even harder? We'll see. But for now, Baloyi is standing firm, backed by history.
As a court case, my lord, just to address two issues, and the first one relates to argument advanced by almost all counsel that the common law exception of executive statement must be antecedent in nature. We submit, my lord, that that is not the only method, and in this regard, we wish to refer to the case of Rex versus Miller and another. It's a 1939 appellate division at page 106, and this, my lord, is demonstrated by the argument of Advocate Baloyi when he quoted the Sheikh's case, indicating that the facts in question was written before the accused was charged. Looking at page 115, Author Mayor J.A. as it then was, had the following to say. An examination of the textbooks shows that there is a well-recognized rule that the acts and declarations of one conspirator are admissible in evidence against another, provided that they are acts performed and declarations made in the furtherance of common purpose. Under this rule, admissions made by a co-conspirator after the purpose had been completed, consisting of a relation or narrative of some part of the transaction, have been held to be inadmissible. Then the learned judge of appeal proceeds at page 117 as follows. It is very true that one mode of showing conclusively that a conspiracy has been entered into between various persons is by showing antecedent acts, and this is what counsel have been at pains to emphasize, pointed in particular by Advocate Baloyi. Or acts which may bring them together. But, and this is very important, but this is not the only mode. Another mode is by showing various acts subsequently in which they have concurred, acts done by them, leaving it afterwards to be inferred by the jury from the agreement or disagreement of those acts with reference to a common design, whether such common design existed or not, And just finally, at page 118, Mayor J.A. expresses himself as follows. If we ignore the word conspiracy and take a simple case arising in our law where A is charged as a socius in a crime committed by B, there are two elements for the Crown to prove. A, the acts done by B in the course of the commission of the crime, and B, the complicity of A in those acts. And my Lord, this has been the high watermark of our argument, that the evidence of Constable Zungu shows that there was an association of the persons involved at the hostel, testified as to what happened before the departure of the accused, and also upon their return, how they followed one another, and as to what happened, accused number one handing the .38 to Gwabeni, and subsequently, while standing on a chair, announcing whether people have heard that Senzo Mewa has been killed. And if we take that, my Lord, in conjunction with the evidence that has been tendered, in the pointings out and his own confession, my Lord, the accused spells out the role that he played. He said his role was that of a lookout. We've heard the evidence of the witnesses who testify that those who were in the house, that they were in the house, two people burst into the house. They've identified at least two of the witnesses, my Lord, Mizandile Kumalo, Tumela Madlala, have identified accused number two. So one of the two persons who burst into the house, and accused number one spells out the role that he played, namely that of a lookout. We therefore, my Lord, submit that if one looks at the evidence in totality, a picture emerges of executive statements.
And that's where the courtroom left off. Baloyi is standing tall, defending his strategy with the weight of history behind him. The defense insists he's crossing the line, and Judge Ratha caught in the middle. As the battle over this 1939 precedent heats up, the real question is, will it change the direction of this trial? Now, I want to hear from you. Do you think Baloyi is justified in using Ntanzi's statement to challenge Sibiya? Is this a smart legal strategy or a desperate move? Should a ruling from 1939 still shape justice today? Let me know what you think in the comments below. This fight is far from over, so stay tuned, because things are only getting hotter in that courtroom. Thank you very much for watching. Don't forget to like, share, and subscribe. On the road to 4,000 subscribers, if you are watching outside the club, kindly do so and help me reach there. I'm Skybreach. Until next time, goodbye.